to let. Good afternoon, dear participants. This is Someshwar Sati from the Center of Disability Research and Training. Welcome you to lecture 2 of our certificate course in disability studies titled An Introduction to Disability Research, a Legal and Social Studies Perspective. This certificate course is organized by the Center of Disability Research and Training, Kirorimal College, in collaboration with the National Center for the Promotion of Employment of Disabled People, NCPEDP. It is my great honor and privilege to welcome back a face that had captured your imagination and tickled your intellect on Wednesday. Welcome back, Subhash ji, and we are all looking forward to your lecture today with our breaths held, because you are indeed a mesmerizing speaker. But before I hand it over to you, sir, it is also a matter of great pleasure to welcome back our sign language interpreters, Preeti ji and Arun ji, and of course, the man who put together this program, Akshay ji. So it's over to you, sir, and Akshay will be there to help you with the technical support and moderation as today's day unfolds. The platform is all yours, Subhash ji.
Thank you so much, sir. Akshay, I think my screen sharing is perhaps disabled. So if that can
I'll just give you the permission, sir. 1 second. Yes, sir, you can share it now.
Thank you. So I hope my screen is visible now.
Yes, it is. Yes, sir.
Yes, yes.
Perfect. So thank you so much for the wonderful introduction, Sati sir, and the opportunity to speak to so many bright minds from across the nation, and to the NCPEDP, the leadership which has taken this lead to organize this wonderful course. And this is the rare pleasure that I was the one who got this opportunity to start this session, this course, and I'm here again before you, and probably I'll have another opportunity to discuss a few more things during the course with you. So today I'm going to be focusing on a bit of how the international law and the national laws have evolved over a period of time. Initial part probably we did do the sensorization on disability issues, and I was so glad to have so many questions, and I'm also very pleased to have very awakened and enlightened audience, and I see people from cross sectors, advocates, or people studying law, scholars, and people working. So it's such a wonderful audience, and it's always a pleasure to speak to such an audience.
So sorry, Subhash ji, I would like to just tell you that you have 60 minutes for your talk and 30 minutes for your interaction.
Okay.
Right? So that's the rough time. You could take 10 minutes more or less, that doesn't matter.
No, I'll
that's
take 10
the rough
minutes.
division, 60 plus 30.
Okay, thank you, Ji. Thank you. So let me straight away jump to the milestones. I think I'm going to be around it, and this gives a bird's eye view. Something on the screen that's presented, I'll read that out and I'll discuss that for the benefit of my blind friends. And so, if you look at disability and if you look at human rights, I go back to 1948 when the UN, in 1945, the UN was created after the end of Second World War. And a need was felt that the peace should prevail, human growth should happen, human development should happen humans should live peacefully and nation should not fight. And solutions should be brought out through amicable means, by discussions, by sitting over the tables, and not through wars killing so many people. So in 1945, this UN was created, and it took about 3 years to have the first declaration on human rights. That was Universal Declaration of Human Rights in 1948. Until then, across the world, there was a charity-based approach towards disability, not just here in India, but I think across the world in most of these countries. The approach was of neglect, approach was of a charity. Well, at the end of Second World War, when these soldiers came back disabled, so these countries started to realize, that these people have shown valor, and they have laid their lives and laid their limbs for protecting the nations. So there was some respect, and gradually the Western countries, especially US and few other countries, started to evolve and started to talk about it and started to give some rights, and it started. So until 70s, you would say, while it started in the Western countries in 50s, that there was some talk happening and some measures being given and some respect being given to persons with disabilities, especially who became disabled in the war. Until 70s, you'd find India did not have much to offer in terms of congregation of people or gathering of people with disabilities. It was more or less a charity-based approach, a neglect of state. Literally, people were left to fend for themselves. They were considered as burden on the society. See, you can relate to not very long ago, about 30 years ago, we had one Adolf Hitler, who wanted to kill the disabled people because they were useless, for the society as per him. So the society as a whole was evolving. So in towards 1971, when the UN had declarations on the rights of mentally retarded, I'm using these words because this was the prevailing knowledge on the use of terminology, and this is how it was termed as. So it was Declaration on the Rights of Mentally Retarded in 1971 in the UN. Voices began in India during those times, but from one or two disabled people. It was more of a battle between few individuals against the system, saying that our rights are not met. We need rights. We need equal rights. And there were few NGOs as well, single NGOs, but these were NGOs who were focused on single disability. And usually these NGOs were funded by, people from within India and some foreign missionaries and for foreign funding institutions. And within India, industrialists were funding, and they were trying to bring succor to persons with disabilities through the NGOs. But largely you would find up to 70s or from 71 up to 70s, it was more or less single disability led NGOs working in silos, not really connected to each other, not really talking much to each other. But after 70s, there was gradually people started, getting aware that yes, there are other disabilities as well. And there is a lot happening at the level of UN and other international agencies. 1971, after this declaration on the rights of mentally retarded persons, 1975, we have a major declaration on the rights of disabled persons. So because initially perhaps it was felt that it is just persons with mental challenges or cognitive challenges whose needs were really not met and they really needed to be protected. And while others can still fend for themselves, but 1975, rights of all the persons with disabilities, there was a declaration from the UN. In 1980s, in the 1980, the World Health Organization came out with the International Classification of Impairments, Disability and Handicap. So we call it ICIDH. And during this time, even in India, gradually, especially in India, there was a shift in the policy framework. From welfare, we started moving towards a developmental model, which started transforming to the developmental model and seeking people into, I would say, into the progress, the developmental programs. In fact, 80s until 80s, none of the census in India had included persons with disabilities, or there was even a count of persons with disabilities. There was no enumeration at all of this category. 1981, after a lot of advocacy, because since they were not numbered, so no plan happened, nothing from the state level was happening. So 81 census did, for the first time, had 3 disabilities. So majorly the 3: hearing and vision and physical. So these 3 disabilities were sort of added for the first time in the 81 census. In fact, after 10 years in 91, it actually disappeared, and there was again no counting of persons with disabilities. But 81 actually marked that shift in the policy. And in fact, in many of the government jobs, there was reservation was started of 3% for these 3 categories. Of course, it was for lower level positions, as at junior level, like D and C level positions. 1981, the UN declared International Year of Disabled Persons, IYDP, that was proclaimed. And I think in 1982, we had the World Program of Action concerning disabled persons. So you will see the language, the language which is used successively, it's changing from mentally retarded persons in UN DSCR, absolutely nothing being there. We are moving towards a term called disabled persons. So 1982, when the World Program of Action was adopted, there was a lot of effort to integrate disability into programs. 82 to 93, the UN declared it as the decade of disabled persons. And this was the time, this was the decade when many countries started to realize that the persons with disabilities are not just, if you don't focus on them, they will remain dependent on others, and it's an economical burden. So therefore, they need to be given opportunities. They need to be brought into the mainstream. So the focus gradually was on the rehabilitation. So you can say the first day when we looked at the medical model, so it was actually a medical model which was in practice, and the whole effort was to let us fix them. That was the approach. Let us fix them. So entire rehabilitation mode was sort of pushed by different governments, by different organizations, and you'll find that during this period, India too started getting ready for a lot of these changes. In fact, you will see India created the Rehabilitation Council of India Act in 1986. So it was that push of and the knowledge that was happening at the international level that largely India also enacted this. And there was the Mental Health Act that was enacted in 1987 around this time, so that people could be treated, there could be rehabilitation programs, and there could be workforce manpower who's trained to help persons with disabilities around this time. So 1983, the International Labour Organization adopted the Vocational Rehabilitation and Employment Disabled Persons Convention. So the focus went on to, having them work, having them become dependent financially so that they don't remain burden on society. 1992, the United Nations decided the 3rd December would be celebrated as International Day of Persons with Disabilities. 1993, you see how it's evolving. The UN adopted standard rules on equalization of opportunities for persons with disabilities. Of course, this was non-binding. Of course, this was non-binding, but there were rapporteurs. The post of rapporteur was established, which would see how countries are implementing these particular rules. in 1990, from 1993 to 2002, it was declared as the Asian and Pacific Decade of Disabled Persons by the UN. And in fact, it was during this time that India had the first of its own law on disability, and we call it in short PWD Act, but its full form is the Persons with Disabilities in bracket Equal Opportunities, Protection of Rights, and Full Participation Act 1995. So this was after this meeting in the Beijing, when this decade of disabled persons and the proclamation was done, that India had this law notified. Of course, there was not much discussion, but the first time the substantive provisions of this act were around prevention and early detection, education, employment, affirmative action, non-discrimination, barrier-free access, research and manpower development, and institutions for persons with severe disabilities. So basically, it also, for the first time, talked about registration of institution and ensuring that persons who are trained are only providing services to persons with disabilities. So this has been the development over a period of time. In 2001, there was a proposal from Mexico, and the UN General Assembly established an ad hoc committee and to study the convention, the proposal for a convention on the rights of persons with disabilities. The challenge was, the background was that all the human rights convention from the UN until now had actually failed to look at persons with disabilities and to bring any succor to them. And they did not find that it really helped them. So for the first time, the persons with disabilities, were actually participating themselves, and to the nothing about us without us, that concept that UN Convention brings. So for the first time, a convention had maximum participants who represented from different countries, were themselves persons with disabilities, and were debating, discussing what the convention should be. In May 2002, the WACO Millennium Framework for Action towards an Inclusive, Barrier-Free, and Right-Based Society for Persons with Disabilities in the Asia and Pacific was declared. On 13 December 2006, the UN Convention on the Rights of Persons with Disabilities was finalized, and it entered into force on 3rd May 2008, exactly 2 years thereafter, after having signatures of about 20 countries. 2006, only the UN launched the global initiative, the G3ICT. This was an advocacy initiative of UN GAD, the United Nations Global Alliance for ICT and Development. And 2015, we had 2030 Agenda for Sustainable Development. So that was a brief, outlook of how in the international law from the time of the Second World War has evolved over a period of time, and how the language has changed from the mentally retarded persons to disabled persons to inclusion of all persons with disabilities and using a persons first approach. Coming back to our country, to India, until 1995, the entire, I would say, rights of persons with disabilities was anchored in the Constitution of India. That was the ultimate anchor. So all the domestic statutes, they derive their roots from the Constitution. So including the disability and accessibility legislation. So all the cases that were filed in various courts, they all were citing Article 15. They all were citing the fundamental rights of equality. I'm sure many of you are legal students, many of you are researchers in the field of law and disability studies, and are students of social science. Our Constitution has two very important parts, which from the purpose of rights and duties. So Part 3 of the Indian Constitution, it enumerates fundamental rights which are enforceable, as all of you know. like freedom of speech, liberty, equality, freedom of religion, etc. And part 4 is directive principles of state policy. So this has certain socio-economic ideals, for example, right to work, to education, to a living wage, to health. So at the time of enactment of this constitution, they were unforeseeable and they were ideals, which the state was directed to strive for. But over a period of time, as student of law, as student of development, we have seen most of these ideals have been read into our right to life by Supreme Court in various interpretations. And you will find on most of these subjects, there are today substantive laws. So though Article 37, as I say, it is unforeseeable, the Supreme Court has already enforced many of them by reading them as part of fundamental rights. So an example that I can give is of Unni Krishnan's case in right to education, where right to education was read into Article 21. So just a few articles, let's look at few articles of under the Constitution of India. So Article 14, the right to equality is mostly talked about, and that it says the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. So this article basically stresses on substantive equality rather than the formal equality. So that means it may not be, these laws may not have universal application for all people, because for some people it may have some special provisions as well. For example, persons with disabilities, for example, persons who by nature, attainment, or historic reasons, or any other circumstance, they are not in same position. So in order to provide them a level playing field, the state under these laws can provide separate treatment. So that's how, with that separate treatment, it would mean the substantive equality rather than just formal equality. So that's the concept of Article 14. The Article 15 is a prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. Now you'll find there is no mention of disability here under this article. And in fact, until 1995, all persons with disabilities actually relied on this article, and we were filing so many cases before high courts and the Supreme Courts, and in practice, if we see, because of the persons with disabilities not getting that right of equality or that attention until this act was created. In fact, if you see, despite Article 15 being there, we did not have, in fact, the service rules of the central government until 95, they prevented entry of persons with disabilities in higher grades of service. We all know that. So they were all relegated to Group D and in Group C. A and B were completely out for them. So it's only after the act came into being that it was gradually started. So Article 15, the realization for persons with disabilities, only started after the act, actually 95 act came into being. Before that, still it was a great fight. Article 19 is another major article which says protection of certain rights. And to me, the important rights that are among freedom of speech and expression, to assemble peacefully without arms and form association or unions. The more important article from the perspective of accessibility and for inclusion that I count is to move freely throughout the territory of India. So we need the entire territory of India to be accessible so that persons with disabilities can move around the country. To reside and settle in any part of the territory of India, that's another important right. And to practice any profession or to carry on any occupation, trade, or business. So as if I am a wheelchair user, I want to be in a certain profession, I need equal access. So, we can actually read and we see so many things flow out from these articles. Coming to Article 21, which is the most important article on which I believe that maximum interpretations have been brought out by the Honorable Supreme Court, reading and almost entire subjects of which were under the state policy earlier, which were brought into the fundamental rights, which were read into fundamental rights, is protection of life and personal liberty. So Article 21 says no person shall be deprived of his life or personal liberty except according to procedure established by law. And Honorable Supreme Court has done such a wonderful interpretation when it interprets life as not just life of animal, not an animal life. It is a life of not mere survival, but a life of dignity as a human being. It is not just physical survival. So similarly, in this very important case, Francis Corelli versus Union Territory of Delhi, 1981, AR 746, the court held that the right to live is not restricted to mere animal existence. It means something more than just physical survival. And bench said that the right to life includes the right to live with human dignity and all that goes along with it, namely the bare necessities of life, such as adequate nutrition, clothing, and shelter, and facilities for reading, writing, expressing oneself in diverse forms, freely moving about, and mixing and commingling with fellow human beings. When I read, every time I read this interpretation and what the bench held, I feel in every sentence, I have equal access as a preliminary requirement. And especially for persons with disabilities, accessibility to the services, built environment, and all other forms that the law provides, the existing law provides, they all are held within this particular interpretation of Article 21. After that Tony Krishnan judgment, the Government of India brought in an amendment through which is 86th Amendment, very popular amendment, wherein right to education was brought in as a fundamental right. Through this amendment, Article 21A was inserted, and it said that the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. Now, for persons with disabilities, after the Act came in the 1995 Act, it has been, the age has been not 14, but 18. So in case of persons with disabilities, the free and compulsory education is up to the age of 18 years. Right to privacy is another right. So I'm just sort of touching upon various rights that were read into the Article 21 so that we see how the Honorable Supreme Court has dealt with this particular right and how persons with disabilities have also benefited from the whole process. The right to privacy is a new right that was read into Article 21 in Rajagopala versus State of Tamil Nadu. And the court held that the citizen has a right to safeguard the privacy of his own, his family, marriage, procreation, motherhood, childbearing, and education, among other matters. In fact, right to livelihood was versus Union of India, and you would have
Sir, your voice is not coming, sir. I think Subhash sir has just dropped off the call. There's some internet issue. Let's just wait for 2 minutes. He'll be back.
Are you able to hear me?
Yes, we can.
Oh, I don't know. Somehow, perhaps it just there was some problem somehow. I don't know what happened, but anyway, I'll continue with that.
Yeah.
So
You might have to reshare the screen, sir.
Oh, I see. There was perhaps some problem. Just a sec.
Yeah, yeah. Yes, sir, it's visible now. Sir, are you there? Sir.
Yes.
Yeah.
Probably I had problem in unmuting myself. This technology can fail you sometimes when you need it most. I'm so sorry for all this.
No issues, sir.
I'm back to the slide. So I was perhaps on right to food. So the right to food, did I cover it when you lost me? When you lost my voice, were you able to cover it or because I had
No,
almost
sir.
read this slide while reading.
No, sir.
Okay, fine. So right to food was also read as part of Article 21 in this very famous case, Kapila Hingorani versus Union of India in 2003. And the court very clearly said that it is the duty of state to provide adequate means of livelihood in the situations where people are unable to afford food. And again, right to safe drinking water is one of the fundamental rights flowing from Article 21. And there are many other rights under Article 21, which is like right to fair trial, right to health and medical care, protection of tanks, ponds, forests, so which give a quality life, right to family pension, right to legal aid, counsel, right against sexual harassment, right to medical assistance in case of accidents, rights against solitary confinement, right against handcuffing and bar fetters, right to speedy trial, right against police atrocities, torture and custodial violence, right to legal aid, and be defended by an efficient lawyer of one's choice, right to interview and visitors according to prison rules, and right to minimum wages. So all these have been read into by Supreme Court as a part of Article 21. So that was about the Constitution. Let me jump back to the very famous and first of its own kind legislation on disability, that was Rights of Persons with Disabilities Act. The Persons with Disabilities Act, Equal Opportunities, Full Protection of Rights and Full Participation Act 1995. So this act actually for the first time spoke about the rights of persons with disabilities, and it did cover a gamut of activities, right from, it did cover actually early intervention or early intervention. It also covered prevention, and many people with disabilities felt that prevention perhaps is not required in this law. It should actually go to the other health related budgets and health related laws, and it should be limited to the rights of persons with disabilities. And we are not looking at preventing disabilities in this law. That has got no space in this law. In fact, this sentiment was stayed, and I think in 2016 law that we'll be doing subsequently does not have this particular mention. So I am focusing on, among other things, on accessibility. So there were some direct provisions in 1995 Act on accessibility, though it was scanty, but then it still made a lot of impact and some early developments and some, I think under this law only we developed a very good case laws based on the rights of equality. So chapter 8 of this act was non-discrimination. Section 44 was dedicated to transport sector of non-discrimination, and it spoke about, very scantily spoke about adapting the rail compartments, buses, vessels, and aircrafts. So basically transport sectors, and then adapting the toilets in all these spaces. So rail compartments ko adapt karna hai, and we need to adapt toilets in these, so to make them accessible to persons with disabilities. If you look at this, it did make an impact, but I see even today, I do not have accessible toilets on board many of the aircrafts that are going that are flying within the domestic areas. So just a feature that I still feel pained about. 45 section, it required the government to provide auditory signals at red lights for the visually impaired, causing curb cuts and slopes in the pavement, engraving on edges of railway platforms and on the surface of zebra crossings, warning signals at appropriate places. So in terms of accessibility, see, because since I'm an accessibility professional, I majorly deal in that area. So I have purposefully not covered all that about education and about health and about many other registration of institutions and other provisions that the 95 Act had. So I was focusing on accessibility just to give you a broader view that it actually covered these things, but very scantily they were covered. So they did not actually bring succor to people. They did not bring a lot of impact into the community. But yes, the initial steps were taken. There was a lot of awareness. I think using this law, we were able to do, as lawyers, we were able to do a lot of advocacy around rights of persons with disabilities, and maximum advocacy happened in the area of employment. So many people, in fact, who could never think that they would be employed in Group A and Group B post were able to be employed under this law, under the using reservation. And in fact, if I remember one of the cases in early 2000, when the Delhi government was filling up the post of principals, I'm talking of perhaps 2003, perhaps. So Delhi government was filling up some 90 posts of principals in different government schools, and they did not provide reservation to any person with disability. And it was under using this act, it was stayed in the Delhi High Court, and it remained stayed for almost like 2.5 months. And there was huge pressure on the government to provide reservation at their senior level to blind people. And the government had to agree, looking at the legal provisions and the court order. So just trying to say that this act actually created lot of impact. 46 section provided that there will be ramps in all public buildings, braille symbols and auditory signals in elevators or lifts, ramps in hospitals, PHCs, and rehab institutions. And that was it about accessibility in the 95 law. And because of which, not much happened, but yes, still so much happened, and we were able to do a lot of advocacy. But we had so many learnings out of this from the 95 Act, and a huge case laws were piled up, and they were successfully used in subsequent cases.
I'm sorry, sir. Can you repeat the name? A successful case was brought out by NAB?
By NAB.
By National Association of the Blind. Okay, thank you.
No. I did not say by NAB, but by different lawyers who are practicing on this particular subject. So we had so many organizations, individuals who were fighting these cases. Majorly, a lot of PILs were done by National Federation of Blind, All India Confederation of the Blind, I think the DRG, and several individuals. I think few of them are also right here. The Nilesh Singhit, Rajiv Raturi. I mean, several cases were brought out, and which you can definitely be cited and are available. If you search on the internet, all these cases are available. In fact, I also maintain a website called Disability Rights Through Courts, and it has a lot of such cases mentioned. So during this time, simultaneously there was this UN convention was being finalized, was being discussed, and there was a lot of awareness around it. And in 2006, we had the national policy, the first national policy on for persons with disabilities. And you'll find all the learnings that we had from various case laws, all the learnings we had from interaction and implementation of various provisions of this particular case, this particular law, and other laws that were finally brought into and the NGOs had put forward those suggestions, and this national policy incorporated almost all of them. In fact, the national policy of 2006 reflected the aspirations of people with disabilities of this country, and it showed that it was a glimpse to the government that this is what we wanted. And I'm just reading out one section, probably that deals with creation of better environment. And I'm sure this is available on the internet. You can read out the entire policy, which captured the various challenges that people faced in realizing rights of persons with disabilities. This is one example. So in chapter 6, section 51, we said, the policy said the public buildings, functional or recreational, transport amenities, including roads, subways, and pavements. So, we had to define this, that many subways were becoming inaccessible and pavements were inaccessible. So we had to bring it as a part of transport amenities. Transport, railway platforms, bus stops, terminals, ports, airports, mode of transport, bus, train, plane, and waterways, playgrounds, open spaces, they all would be male accessible. So that was the policy. That is a very different thing, that the policy never had any funding support or any mechanism to support implementation of these. But then this reflected a larger, I would say, aspirations of people, that this is what they want and these are the lacunas in the existing law. And eventually when the law is amended, and there was a lot of pressure on creating a new law or amending the existing law in light of the convention, because by the time India had signed the convention, and so much of knowledge had already circulated among the stakeholders. So it spoke of, for the first time, it said sign language in all public functions would be encouraged, because we felt that the earlier law did not provide for it, and mostly persons with, except for persons with physical disabilities, for other disabilities, accessibility was very limited. It was just limited to, and for blind people, it was limited to, some beepers and some tactile, engravings on the edges of platform and on crossings. So it did not go beyond it. So this was a major addition. Then we felt that all these, architects and engineers who created these environments were not really aware of this. So then this was a major recommendation, and you'll find this also in the law, in the new law that will be seeing, the 2016 law, that the curriculum of architects and civil engineers would be modified. And in-service training will be given to all these officials who deal with the built environment. And then it was also felt that the National Building Code is a document which is voluntary in nature. So there was no binding rule which will ensure that the built environment is accessible. And it was felt that the building bylaws were not comprehensive. They were very scantily touching issues of accessibility. So this was brought into the national policy, that there will be full adoption of comprehensive building bylaws and space standards on barrier-free built environment. And any new building which are coming up will be completely barrier-free. The earlier law had the issue that only public buildings, which was understood as government buildings, would only be required to be accessible to whatever degree that was indicated in the law. But then we realized that there is such a huge environment which is beyond the government. Malls were coming up, privatization, this liberalization was leading to more and more job opportunities happening in the private sector. And all these public facilities were also being operated by private sector. There was a time when a large fleet of buses in Delhi was in the private hands and DTC's fleet was depleting. And it was felt that any service which is open to public should be also brought under this law. And you'll find this reflection in the existing law that we will be doing subsequently. So they all were included here. It also said all state transport undertakings will ensure disabled-friendly features in their vehicles, and railways will provide barrier-free coaches in a phased manner and will make platforms, buildings, toilets, and other facilities barrier-free. And it also ensured that all the industrial establishments, offices, basically public utilities and public offices, including of the private sector, they will provide disabled-friendly workplace for the employees. And all the buildings that are for public use will be audited for accessibility to persons with disability. Pehli baar, for the first time, it was indicated in our national policy how we are going to move forward. That actually gave a glimpse. Of course, among other things, it spoke of banking system need to be accessible and communication needs, basically ICT and public documents to be accessible. So that was a glimpse of the national policy of 2006, which actually brought out the aspirations of people as to what the future law would look like and what the future law should bring in. I'm coming to the UN Convention, which forms the basis of, in fact, any changes that were to be done to the 95 Act. The UN Convention of 2006, I think these are all facts and figures. You'll get it on the internet. For India was among first few countries who signed it. It has a force of law and is being implemented. And Indian laws need to be amended in light of this. So the new law has already come, but there are still many other laws that need to be harmonized in light of this UN Convention. And probably that is an ongoing process. But as a sector, perhaps we need, one fine morning, we suddenly find there is a new law that is, there's an old law which is still, against or contrary to the provisions of this act. So this is something that's an ongoing process, and we need to fight for it. So these principles of UN Convention are very, very important, and you will find them also mentioned in the existing law, and they form the very basis of how empowerment of persons with disabilities should be done, and the state is bound by it. So these are non-discrimination, the respect for inherent dignity, individual autonomy, including the freedom to make one's own choices, and independence of persons, non-discrimination, full and effective participation and inclusion in society, respect for difference and acceptance of persons with disabilities as part of human diversity. Yeah. Is somebody wanting to say something? Okay. Equality of opportunity, accessibility, equality between men and women, and respect for the evolving capacities of children and children with disabilities, and respect for the right of children with disabilities to preserve their identities. So these principles have been also adopted as it is into the new law that we have now. So some major articles of the UN Convention that I want to talk about and are very important from the perspective of inclusion and accessibility that we are working towards is Article 2, where reasonable accommodation and universal design has been given a prime space. And in fact, I'm sure you must have seen some recent judgments that have come underlying the need of reasonable accommodation, and denial of reasonable accommodation would actually mean discrimination on the basis of disability. The law so provides. Article 9 is around accessibility, and accessibility of various kinds. We'll see that. Article 18 is around liberty of movement and nationality. Article 19 is on living independently and being included in the community. 20 is on personal mobility. 21 is freedom of expression and opinion and access to information. 24 is on education in an inclusive system. 29 is on participation in political and public life. And 30, most important is participation in cultural life, recreation, leisure, and sports. I find these articles very important from the perspective of accessibility. And accessibility forms the very basis, which is like a precursor, which is a precondition for inclusion and for empowerment of persons with disabilities. I hope you all must have read the definitions around, but then the few that I feel that each person who's not, I'm sure the sector people would know, it will be teaching to the choir, but people who are not from the sector, from the disability space, it will be very interesting for them to know that these definitions are also incorporated in the act that we have now and are very crucial to ensure that we check discrimination at the very start itself. So it defines for the first time what would be considered as discrimination on the basis of disability. So it would mean any distinction, exclusion, or restriction on the basis of disability which has the purpose or effect of impairing or nullifying the recognition, enjoyment, or exercise on an equal basis with others of all human rights and fundamental freedoms in the political, economic, social, cultural, civil, or any other field. And it includes all forms of discrimination, including denial of reasonable accommodation, as I just said. And reasonable accommodation has also been defined in the UN Convention and also incorporated in the Act. It means necessary and appropriate modification and adjustment, not imposing a disproportionate or undue burden where needed in a particular case to ensure to persons with disabilities the enjoyment or exercise on an equal basis with others of all human rights and fundamental freedoms. So I'm not touching universal design. We did it earlier, but Article 9 on accessibility does cover the entire gamut of accessibility from the buildings, road, transportation, indoor, outdoor, schools, housing, medical, workplaces, all kind of buildings, including transportation, including information, communication, and other services, and that also includes electronic services and emergency services, etc. And the convention actually required the various state parties to do this in a very programmatic way, to implement access. So to implement access, first you need to have minimum standards and guidelines to guide various agencies to ensure standards, to ensure accessibility. So it's a develop, promulgate, and monitor the implementation of minimum standards. So right now, if you see, in 17 we had the rules in the country, which initially had about 3 rules. One was about bus body code, one was about built environment, and one was on the ICT, which is for websites, the WCAG 2.0 AA level compliance, and the other one was for document accessibility. So these were standards already issued under the Act, and new standards as per this are coming up from different ministries, so that their ministries are ensuring the implementation of Rights of Persons with Disabilities Act or the UN Convention for which the Act was created. So it also spoke for the first time that even private entities, the UN Convention stressed that the private entities that offer facilities and services, they will also be made accessible. And similarly, training of stakeholders will happen on accessibility issues. Buildings and other facilities will have signages in Braille and easy to read and understand formats. And there'll be live assistants and intermediaries, including guides, readers, professional sign language interpreters, to facilitate accessibility to building and other facilities open to public. Different forms of assistance and support to ensure access to information and access for persons with disabilities to new information and communication technologies. And the convention also provided the state parties to promote the design, development, production, and distribution of accessible information and communication technologies at an early age, so that they can become accessible at minimum cost rather than having to be done at a high cost as retrofitting. So in the convention did speak in different articles on that were around accessibility and talking about independence of people to live and being included in the community, and participation in cultural life, recreational leisure and sports, as I just said. So I think I'm nearing my time. I'm just going to touch upon one more area as to why many states still haven't done much on accessibility, and why the central government and the state governments, I'm sure many of you will have these questions as to why different states are performing or faring different levels of implementation of the act or of the provisions or of schemes meant for persons with disabilities, and how a particular state can be forced to act on an international convention. And I mean, it will be useful to know how an international convention is implemented in India from that perspective. So India is actually signatory to the Vienna Convention on the Law of Treaties, that is VLCT. It was entered in 1980, and there's a principle of pacta sunt servanda in the international law. So VLCT, Article 26 of the VLCT provides that every treaty signed by a country is binding on it, and obligations imposed by treaties must be performed by the country in good faith. In fact, in some countries, international law can be straight away read into the domestic laws without any formal requirement. So without any creating of a domestic law or that's called principle of monism. So international law does not become binding under Indian Constitution until an appropriate domestic legislation is enacted. But I mean, we call it principle or doctrine of dualism. We see it in Article 253, which actually gives Parliament the power to make laws that implement international law. In fact, for a long time, disability laws were not implemented, and the center couldn't do much on the disability until India signed in 80 this convention. And this convention, actually, if you read with Article 253, gave the power to the central government to legislate on this law, which will become enforceable also on the states. So that is why you don't find much, much work on disability into different states, because the center was stuck that the disability is a state subject, and therefore on that list we can't do much. We can't legislate much, and we can do only here. But convention that you see now, I'm sure these can be left to, I can share these with the participants if they want. So the dualism का जो principle है, Article 253 में the courts did not bind themselves in some of the cases, like Vishakha versus State of Rajasthan in 1997, where the Supreme Court actually noted that regard must be had to international convention and norms for construing domestic laws when there is no inconsistency between them and there is a void in the domestic law. So I think I'm nearing 5:30, and I want to leave a lot of space. I've been already told, so I need to perhaps abruptly stop here, and maybe it will be good that if I can take more questions rather than just keep speaking, making it a monologue. So I'm just stopping here. Thank you for this opportunity. I hope I may have done some justice to this subject. Thank you so much. Akshay, are you around or?
Yes, sir, I am there.
Okay, so do we open the house for question and answer, or do you want me to continue? And
Guys, if are any questions, please go ahead one by one. You can raise your hand and we can start with the question answer sessions if anyone has.
Hello, sir.
Yes, please.
So my question is whether the different states in India can make or modify the existing law, or they have to just adopt the central's law of persons with disability.
Great. Thank you. Thank you. That's an interesting question. See, the disability is a state subject, right? So while using the Article 253 of the Indian Constitution, the central government has already brought in a law to implement an UN convention. So by that reason, it actually becomes applicable to various governments, and various governments are bound by this international law, the UNCRPD. But many states, see, what happens is how these states implement that law. Either they adopt the same law into their states, because eventually, since disability is a state legislation, is on the state subject, so the central law is as it is, but the law has certain sections which gives power to the state to promulgate rules or to notify rules as to how this law will be implemented in their state. For example, what will be the constitution of the state board? What will be the constitution of research committee, or how the courts will function in that particular state? So for this, these different states will bring in their rules to implement that law. So to that respect, yes, the state will notify this law, and with, of course, there can be slight changes, but these changes, if they are against the UN Convention or against the main law, can always be challenged in the court of law. So, for example, the state of MP decides that I will not give 3%, I'll give 6%, to persons with disabilities. In the earlier law, it happened. While the central law provided 3% reservation, the state of MP went on to give 6% reservation. So these, where you want to enlarge or enhance the facilities, or these smaller permutation and combinations are definitely permissible. But anything that state brings in rules or in the law that they adopt, they can't be contrary to the central provisions or the convention for which they have been brought in. I hope that clarifies.
Yeah, thank you, sir.
There is a small request. Please introduce yourself when you are asking a question.
Anyone else? Do we have any more
Hello.
questions?
Hello, this is Hema from Delhi University. So this question might be an addition to what Sir just said about the dual policy at the state and center. So it is a query that since state takes the major role in deciding who is a disabled or not, because the major idea here is how does when a person with disability goes to a required hospital, right, to get a disability certificate, so it is the state authority which provides you one. So don't you think that this dual system is creating a problem in uh, getting the right numbers?
Okay. Thank you, Emma, for that question. I think probably I need to clarify that when I say dualism, that see, as students of Constitution, we know there are, under the Constitution, there are 3 lists that are there which decide as to who will have authority to legislate and create laws on that particular subject. Okay. So there is one central list, which you call it union list, and then there is one concurrent list, and then there is one state list. The state list has subjects on which the state has complete authority to legislate and create rules, bylaws, etc., etc. Concurrent list is something where the center as well as state both can legislate, and this union list will have where the center has exclusive power to legislate on those subjects, right? So disability has been on the state list for a long time. It does exist even today, but by use of section 253, which provides power to union government to legislate on subjects to respect the international conventions that India has signed. So disability is one such convention, and by signing that convention, the central government or the Parliament of India, using that Article 2, the power of 253, has created this law which is enforceable across the nation. Okay, so when it's enforceable across the nation, and that is how all the states have no option but to respect it and implement it. The procedural issues are within the law, that the law says that the states under this section will create their state boards and state advisory boards and a state team for this particular subject. So these are within the act, because India, as you know, it's there are several, it's a federal system where we have states and then there's one union, and it's not that center decides and all the states on all the subjects will have to agree. So these states, yes, they will be binding by it, but then when it comes to certifying a disability of a person, eventually all the disabilities that have been identified by the central law are accepted as the disabilities under the act, and each state will certify those disabilities. In fact, for this purpose, the government of India has already created a website called Swavalamban, and on which any person from any part of India can register, and his data will be shared with the nearest hospital, government hospital, where he'll be certified. The central government has also created detailed documents and detailed processes as to how evaluation will happen for each disability, and awareness raising under this particular subject has been going on across India. So it's not that a state will not accept a certain disability to be a disability under the law. They are bound by it. So if you are a vision impaired person in Delhi, you will have the same certification in any part of the country. So similarly, all the disabilities that are indicated in the act, they will get the disability certificate across India in any of the state, in any of the union territories, and eventually they don't need to travel for certificate to Delhi. Yeah, they can get it in their areas, in the district hospital and whichever hospital that is notified for that purpose. Right. So it is not that state will deny that it is central it is in the central government law, so we will not give you a certificate. The only problem perhaps which may be happening is some states have not yet been able to constitute medical boards, or medical boards are not regularly functioning, or sometimes there are no doctors available. So boards do not sit and assemble and don't issue certificates in time. But after the Swavalamban thing, a lot of things have got streamlined. And since it is also gradually being linked to UDID, so things are coming onto digital space, and there is a lot of tracking that is happening. And any person who's not getting a certificate or is facing problem can definitely use mechanisms that exist within the law.
Thank you, sir. That helps.
So there's a question from Santosh Mahaldar. Do you think that state should focus more on disabilities to empower them? Yeah, definitely. It is not just state, it is a legal binding, the requirement under the law that the states have already been indicated as to what their duties are under the act. And of course, the variation do exist. A few days ago, there was a news about the pensions. One organization had raised these issues, probably one in the parliament, as to what is the disability pension in different states across India. And since this is a very state subject, central government will not decide ki you give a disability pension of 10,000 or 5,000 to persons with disabilities. It is a state subject. So state will decide. Center can say, yes, disability pension should be given to meet the needs, but then state will decide as to what amount it will be. So therefore, while the state like Delhi, Goa may have more than, perhaps 3,500 or whatever, and some state will have only 300 rupees monthly pension. For example, Delhi may have said just say 3,000 or 2,500, and some state have just 1,000, some state have 600, and I think 300 is the lowest amount, that is perhaps, or 200 or 300 is the lowest amount under the pension. So these issues do exist in the country that perhaps needs a review, and so that states are doing sufficient for persons with disabilities and to empower them and to respect the law, that is the law of the land, also the constitution, because we all know 200 rupees mein kisi ka kuch nahi hota hai. You can't even recharge your mobile phone in that money. So it is such a pittance.
Yeah, good evening, sir. May I ask some questions?
Yes, please.
Yeah, sir, this is Dr. Pankaj Singh Kushwaha. And first of all, sir, thank you for this insightful presentation. And sir, I have 4 specific questions for you. The first question is that, as you stated that you are a kind of a accessibility expert. So, sir, there is a RERA, the regulatory authority of construction of public buildings like societies, living societies and all. So do you detail it that there is accessibility norms that are applied over there? First question. And second question, so since, let me tell you a little personal thing, because my height is 6.4 and I have collided and I have had so many injury at the railway station and some other public building like roadways in Uttar Pradesh. So the accessibility norms that India has adopted is having some accessibility in the air, or kind of a height in terms of height also, or not, or it should be included. What is your opinion on it? And the third question for you is, sir, due to Corona, so many financial institutions have made their services online. Due to online services, they have introduced video KYC. For example, if you are claiming or you are availing any financial service in any bank, you may go for a video KYC. That the 5-fold instruction is given, and the last stage, if they will able to know that a blind person is doing video KYC, they are directly denying it. And it happened with me with 2-3 financial institutions, because I was testing that they have introduced or not. So like ICICI Bank, Citibank, and so many banks have done that. And fourth question, if you can comment that I'm not concerned about that what a professor from Delhi University, Sai Baba, what he has done. But do you think while punishing him, court has taken a consideration of disability and the norms of punishment? Thank you.
Pankaj, I may not have that good memory to remember all the 4 questions, but I will start in the order that I remember. So I think I remember the first question, perhaps about RERA, and and second was perhaps on video KYC. Okay, so let me RERA se pehle bhi aapne kuch pucha tha, that you can ask me again, but let me go one by one. So I'll start with the accessibility of video KYC.
Yes, sir.
The country has India as a nation has already indicated in its Rights of Persons with Disabilities Act that we'll be reading, that will be doing another lecture on subsequently. And today I thought we'll be discussing more on the international convention, how they impact the country and how they impact in various areas. So my intention was that, but anyway, I know issues come back to something that we face on an everyday basis, and these are good platforms where we can sort of discuss them and also let other participants know as to what are the current issues that people face. And this is such a simple, I'm sure another very similar issue is of the CAPTCHA that is often used on the websites where
Yes.
the blind people cannot access. So this is, I feel this is another CAPTCHA which is probably creating access issues. But Pankajji, these can be challenged immediately through legal processes, because the law is very clear. Law is very clear that any services that you provide need to be accessible. This is a part of a service, and the service accessibility deadline under the existing act has already passed. It was 2 years. And if the banks have still not made their systems enabled for meeting the needs of diversity of people, such as blind persons, then they are faltering on that count. So therefore, one simple petition against all the banks that you just cited, I'm not naming them, but against all the banks can lie before the Court of Chief Commissioner for Persons with Disabilities. One notice to all of them. And you can also make the IBA, the Indian Banking Association, as a party to this. And if you want, you can also have the Minister of Social Justice or Minister of Finance also as party to this. But IBA and the banks definitely should be there as party. And a simple notice will do the trick, because they can't have it inaccessible, definitely. And let me tell you, the country already has notified its first ICT standards. So ICT, abhi aapne dekha hoga कि ICT का जो पहला standard है, it is already finalized and it is notified by the Bureau of Indian Standards. And I think conformance standards are also in the pipeline, and they will also be issued very soon. And these will be issued under the, I believe, under the Right to Persons with Disabilities rules in the coming time. So therefore will become enforceable in the court of law. But anyway, that is, leave that aside. As of today, the denial to you of the video KYC having been introduced, which is inaccessible, is something that is infringement of your equal rights of service accessibility. And you should, I'm glad that you brought it up. We can also separately talk on this, and it can be definitely taken up before the Court of Chief Commissioner for Persons with Disabilities. The best part is this court you need not to spend like legal fees, etc. to file a case. It can be done online as well, sending by email, and this matter can be taken up. So that is about your first issue. Okay, so banks are on the wrong side of law. They need to be taken to task. They need to be told that this is what they need to do, and they are doing it wrong. Second is about RERA.
Thank you, sir. Yes.
Okay, so let me one by one cover. The second is about RERA. RERA does talk about regulating the various these kind of developments that are happening, but I don't think currently RERA has these provisions of ensuring that all all these systems, all these housings are accessible. The guidelines that we have are for public buildings and buildings meant for public. So that means if I go back to the National Building Code, and National Building Code provisions are meant for all buildings of which are public and meant for public use and open to public, including public housing. So using that context, these builders and all people who are actually not complying with this law, see, my simple solution is that best of laws can stay in the statute book and never be implemented if they're not practiced or they're not invoked. So they need to be invoked, right? If RERA is not addressing this issue, we need to invoke the law and tell them that, yes, this is not being done and this has to be done in this way. This is the legal requirement. This is what the law says. So India has so many laws and there's so many authorities. And unless these authorities are reminded that this is also your mandate and please implement it, otherwise you are being on the wrong side of law, that effort is needed. And let me tell you, disability is something that is a subject that, I mean, traditionally media has been thinking about it as a very soft subject, so they did not really get time to cover it in the past. Of course, now media has got really very active with active advocacy from the stakeholders that yes, these issues are being covered. But authorities need to be reminded as to what is their duty under the law, and if they're not doing duty, how they can be penalized under the existing law. The current law has a lot of teeth, right from 10,000 rupees punishment penalty to a 5 lakh rupees penalty. So that's, I know for organization called RERA, it may not be really a huge amount deterrent, but then definitely a small order, a court order, a small judgment, and can raise a lot of awareness besides other methods. So I think these two are my, I forgot what were your remaining two questions. Yes, I think one
Yeah,
perhaps
so
you said about court. One, I
Yeah.
think you said about courts, access to courts, and perhaps accessibility in the jails. Is that you said?
right.
Okay. So accessibility is applicable on all public buildings, including jails, prisons, police stations, and judicial forums. So I think I need not to say more than that.
No, sir,
They-
just I,
yeah. So
Sir,
they need to
I
be
wanted
accessible.
your comment. Sorry. Yes,
Yeah.
go ahead.
So the courts need to be accessible, and the jails and prisons need to be accessible as per law, and the reasonable accommodation that the law provides needs to be provided in terms of the law. So the law stands there, and eventually it is for the courts to ensure that when law is not protected, the law is not implemented, and people approach the court, it is for the court to decide how the law should be implemented. And the law is very clear. The Rights of Persons with Disabilities Act is very clear. Let me tell you, the Government of India, Ministry of Home Affairs has already come up with a draft guideline, if you have already seen, of making the prisons, police stations, and disaster mitigation centers accessible. So you can look up, this guideline is already, I think, on the website, perhaps for comments, and comments also perhaps have been sent by many people. And this will ensure that there are written standards which need to be complied for implementation regarding accessibility in all these buildings like prison and courts of laws and police stations, etc.
Thank you, sir.
I think I don't remember the first question that you
Yeah,
asked.
Just, sir. Sir, just I wanted to know that in the accessibility norms, they have defined some, suppose that I'm going to have to do my ticket on the ticket counter, at the railway counter. Sometimes the counters are so high, sometimes counters are so low, right? So is there any accessibility guideline that person is sometimes taller than required?
Okay.
So
Okay.
they have made some, guideline for that also.
Okay.
Because I had so many injuries while accessing these services or these public buildings.
Mhm. Let me tell you. Thank you, Pankaj. I got your point. So the standard that we have in the country on the built environment, they provide that every access route or every facility will have no obstruction or no barrier, and the barrier would include any barrier which is on the way on the access route, and including vertical barrier. And the law and the standards provide that there shall be at least 2100 millimeter, so 2.1 meter clearance to be given on the access routes and the jahan bhi aap activity kar rahe hain, jahan bhi aap khade ho rahe hain, jahan bhi aap entrance kar rahe hain, all these places need to have accessibility, vertical clearance of 2100 millimeter, so 2.1 meter. So what is your height, as you said, Pankaj?
Yes, sir, 6.4.
No, 6.4 in inches. If you convert it in meter, how much it becomes? It must be less than 2.1 meter, right?
Yes, definitely.
So from that perspective, you are already covered. So that is the standard for doors. That is the standard for all vertical circulations. So I think access route ka hissa hai. Even the door is a part of access route, and all areas in the building are part of access route, and they need to ensure vertical clearance of that size. That's what I can say, that it is already part of law. And if you still feel that these issues crop up, then probably again reminding them that yes, this is another diversity that the departments or authorities need to be concerned about, and they should cater to their needs as well.
Okay, sir. Thank you.
K.
Hello?
Sudhakar ji पूछ रहे हैं, does the central government take any action when any state, for example, Telangana, state removed the department for the persons with disabilities and merged with another one where the officers have no understanding of PWD? Okay. Okay. Thank you, Sudhakar. I think this is a question coming from user. But the central government will not take an action if some state does not have a department. Central government can definitely tell the state to implement the, every state is responsible to implement the central law. And central law perhaps does not say that you will have a separate department for for disability. The law doesn't say, right? And the courts of laws also can perhaps implement only the act, what is written in the act. Act does not say that every state will have a separate department for disability or separate ministry for disability. But these are issues that are dealt with for about administration of justice and administration of a state. These are done by executive and by the selected, I would say, the leaders that we choose and the political parties that come to power by through the process of franchise. So they decide as per, I mean, some, I can tell you in some states, they do not have, in fact, several departments are merged into one. They do not want to create a large bandwagon of different ministers and different departments. So it is absolutely up to the states as to how they want to organize their work, and the state leadership. Probably central government will have no role in this, whether they want to have animal husbandry department separate or being merged or to a certain department, or both charges are given to one secretary or one minister. So this is simply administration of probably administration work, and central government will not have any role in this.
Yeah, so this is Ashwin from Goa. Yeah.
Yes, Ashwin.
Yes, I have a question now. When the central law is silent on a certain provision, okay, and if that is, let's say, a concurrent, it's on the concurrent list, and disability being a state subject, so if there is some sort of conflict, so how does one pursue or push the case where we need to get the disability issues resolved?
Okay. See, okay. So are you suggesting that the disability should be? I know there is a lot of effort from many authorities, many activists and parliamentarians and people in the sector that they want to bring the subject to concurrent list. But I mean, if you want my opinion, I would say by bringing, I don't know how much benefit it will have by bringing the subject of disability on the concurrent list, because by virtue of the Article 253, the union government has already created a law and which is enforceable across the nation. So it has already done that part. Now each government is responsible to respect and implement that law and in turn the UN Convention, because that's something that we as a nation have signed and ratified. And I'm sure when we sign and ratify, all the states are bound to respect it. So maybe you can tell me what specific provision perhaps that we are looking at that state has not done and union government has done it. So I'm not very sure of if you can make it more.
No, my question was, I agree it's a state subject, and there is a particular matter we are trying to pursue. But then the state always refers, that this certain thing is not done by the central act. Like, for example, it's an issue of a license.
Okay.
So under a motor vehicle act, when a license has to be issued, so they again and again refer it that, it's a central law, which we have to respect, and certain thing is not there. So that's why we cannot, provide though they agree that, it's a requirement of a disabled person.
Okay. See, I think what I can understand is perhaps this can be read from the Act also, and you can invoke the provisions of Act when we are talking of right of mobility and equal mobility. So, and that, in fact, UN Convention also provides in accessibility and also in mobility that the states will provide sufficient means for enhancing mobility of persons with disabilities, including personal mobility. So I think using that article and using that section, a lot of states are issuing and giving to persons with disabilities motorized wheelchairs. They're giving them three-wheeled scooties, the additional adapted scooties, and some are also going ahead giving them a little more costlier mobility devices. So that's already being done. And for driving licenses, I think that is also perhaps under, that is under this mobility chapter only. And this can be definitely be invoked to implement that particular thing. And since there are already antecedents, there are already examples and precedents in different states and also union government, you can use them. You can definitely use them to invoke that. Maybe you can, if there is any specific case, you can always get back to me separately from this. I think I'll share my coordinates and probably we can take it further from there. But I can tell you that we can find every little right and invoke that from the Central Act. And if that, and most of these are there in the Central Act, including right to mobility, personal mobility.
Do we have more questions or can we wind up the session?
Hello.
Hello, sir.
Yes.
So Suraj this side. So I'm living in Delhi, and my question is this: that, like you have just told in PWD Act 1905, there are many provision, and if I could recall in Section 45, there was a provision that there should be auditory signals in the traffic signals. So, but sir, in the ground, there's different, like there different reality. So, sir, I would like to ask why there is so much laxity in implementation of these provisions, and is there any specific body in, like in central and state level, to look after these provision and ensure that they are properly implemented? Like, sir, there's what only I can observe is that beside reservation, there is no solid thing that government has done till now, so that PWD members could be empowered. Thank you, sir.
Okay. Thank you, Suraj, for that question. I think that's what these are feedbacks from the field. But let me tell you what I think I made that statement earlier as well, that best of laws can remain on statute book if they're not invoked. Okay. So I can recall one of my professors calling that I know that the very crude words he used to say, but we used to laugh also, but it used to make some sense. And he would say that in his words, he would say the law is an ass. It needs to be kicked to get in, to move it into the action. So just to say in my word that you need to invoke the law. आपको लॉ को प्रयोग करना होगा, नहीं तो अच्छे अच्छे लॉज भी केवल अलमारी में या लाइब्रेरी में रखे रह जाते हैं. And about this, yes, at many places this have already been done. And you're saying, is there no authority or is there any authority? Yes, under the law there are several authorities who can be contacted and who should be approached with representation, complaints, etc., etc., for implementation of the act. So it starts from the state. I mean, if you are not employed anywhere, for example, if you have service-related issues, definitely there are systems and officers created within that department. But since it is a public issue, and under the law, you can definitely reach out to your state commissioner for persons with disabilities. That is one body which is created. It is a quasi-judicial body. At central level, we have the chief commissioner for persons with disabilities, and it is again a quasi-judicial body. You can file a complaint and mentioning who are the respondents, and then it can take up the matters like a court case. It can issue notices to the opposite parties and departments who are not complying with the law. So there are already systems created. We need, and these authorities can also suo moto take action on these issues. So these authorities have been empowered to a large extent. And in fact, in the new act, there is so much, there's a lot of power is also given to them, that once they pass an order, or say, in other words, they pass a recommendation, the recommendation has to be implemented by these authorities within, say, 90 days. And if they don't, they need to provide a reason why they are not able to do so. Then probably the person who has complained has got an opportunity to go with that order and approach the higher courts, for example, High Court or some other authority. So these bodies are already created. It's only that at some places in some states, these positions are filled by political appointees who sometimes are not very interested to take action against their own government officers or government departments. But in many places, yes, these authorities are required to act in terms of law, and they will be bound by the law. They will have to issue a notice. And that is other thing, that something may not really happen subsequently, but eventually it is up to you, that you need to really, pursue that doggedly, and then probably things will really move. And in Delhi, we found at a lot of places there are beepers, there are like pelican crossings were installed, and these beepers were installed. So they were implemented at some places, of course, not at all places. But some reason perhaps was given. They may have their reasons. I'm sure some authorities had given reason that there is so much of noise on the road, honking and this, that. So these beepers actually create further annoyance, and they are sometimes not even audible to persons with disabilities. Perhaps these kind of issues were being raised. I'm not exactly sure why it is stopped, or why people are not pursuing this particular accessibility provision.
Thank you, sir. So in a nutshell, could we say, is it beside the financial issue, it could be the lack of political will on the part of the...
No, we won't. No, we will not say that. See, मैं बहुत छोटे शब्दों में कहूँ, नक्शल में कहूँ तो, और हिंदी में एक बड़ी अच्छी कहावत है कि बच्चा जब तक नहीं रोता है, माँ भी उसको दूध नहीं पिलाती है. Unless you make a noise, unless you verbalize, unless you invoke the law, unless you demand, many a time the authorities are simply not aware that you need it, or they're so busy in the order of priority. There are so many other things which go higher in the order of priority, and this get left out. So isliye it is necessary that we invoke the law, it is necessary that we verbalize it, and it is necessary that we demand the rights.
Okay, thank you very much, sir.
Yep.
Hello, sir.
Yes, dear.
I'm Dr. Amit Bansode from Solapur, Maharashtra. First of all,
Okay.
thank you for this wonderful lecture. My question is, you told during the lecture that the India was one of the member of Vienna Treaty who signed that Vienna Treaty in 1980. Okay, and which mandates that the members have to implement the international conventions or laws. Okay, because that even having signed the treaty, it took around 15 years to actually implement the disability law. Does it amount to breach to that international treaty? Means why this delay was there from India's side to implement that international treaty? Like the United Nations Convention on the Right of Person with Disability was India signed on 2006, but the law came into force in India in 2016. That is around after 8 years. So why there is delay in such implementation delay?
Okay, thank you. I think very rightfully, I mean, that pain is visible in your statement that you just made and the question that you just made. It's true, it's true that yes, it took little time, but as I said, there are ways how different countries implement the international treaties or conventions. So I did not actually detail that out when we were discussing this, but yes, बहुत सारे देश क्या करते हैं, बहुत सारे देश जैसे for example, in some countries, what they will do is they will look at the convention, read the entire word by word and see what they can implement, what they can't. Then probably they ratify it with exceptions. So they might say, okay, I will not be able to implement this article and that article. And they'll say, so I am ratifying this convention with exceptions. So some countries do that. India has signed the convention without any exceptions, but some countries would prepare themselves in advance before they actually ratify it, so that on the day of signing, none of their existing act, none of their existing laws are against or contrary to that particular convention, as the state way implemented. And some countries have this practice of signing and ratifying first, and then taking a process of amending, adapting, studying, engaging with the civil society and the stakeholders, and looking at what are the laws that are still, contrary to this law, or are not, giving those rights, not extending the rights that we have just agreed into this convention. So we fall in the later category, जहां पर हमने कन्वेंशन साइन करी और उसके बाद हमने उसके लिए लॉ बनाना शुरू किया. बिकॉज कन्वेंशन आप देखेंगे, any convention is actually promises which need to be put into the legal terminology and in form of act, in form of bylaws, rules, regulations, guidelines, standards, etc. etc. बहुत कुछ चाहिए होता है उसके लिए. So it usually takes time. Of course, it took a long time. The whole process, I can tell you, was started in I think 2008 when it became enforceable, because 2006 में साइन जरूर किया था, but it did not come into force. कोई भी international convention force में कैसे आती है, उसके वो पहले जब 20 देश साइन कर, कम से कम 20 कंट्री जब साइन कर लेते हैं, तो उसके 2 साल होने के बाद वो फोर्स में आ जाती है. ऐसा उनका एक प्रोविजन है. So ये 2008 में force में आया. It came into force in 2008. Though we signed earlier, but it came into force in 2008. 2008 से हमारे देश में ये प्रयास शुरू हो गया कि हमारे present act को कैसे amend करना है, so that it becomes compatible with the UN convention. तो amendment के काफी सारे processes चलते रहे, काफी सारे stakeholders meeting हुए, civil society ने भी बहुत सारा meeting किया, गवर्नमेंट ने भी कुछ कमेटी बनाया. 2010 में प्रोफेसर सुधा कोल कमेटी बना, सुधा कोल कमेटी, और उसमें और सारे इंस्टीट्यूशंस को एंगेज किया गया. हर बार एक ड्राफ्ट आता था, फिर उसके ऊपर डिस्कशन होता था. सो आई थिंक आई रिमेंबर इन 2010 द कमेटी वाज फॉर्म्ड, 11 देयर वाज अ ड्राफ्ट, 12 अगेन देयर वाज अ डॉक्यूमेंट, 13 देयर वाज अ डॉक्यूमेंट, 14 का ड्राफ्ट सर्कुलेट होता रहा. सो इट एक्चुअली कॉन्स्टेंटली वाज बीइंग वर्कड अपॉन एज टू व्हाट विल वर्क, व्हाट मे नॉट वर्क. कि कोई भी लॉ जब बनता है ना, तो उस लॉ को केवल एक व्यक्ति नहीं बना सकता, और ना एक व्यक्ति इंप्लीमेंट करने वाला होता है. एक सेंट्रल लॉ बन रहा है जिसको पूरे देश में इंप्लीमेंट करना है, तो उस लॉ के ऊपर फीडबैक सभी मिनिस्ट्री से लिया जाता है. एंड देन वी ऑल्सो हैव टू टेक फीडबैक फ्रॉम different states as to how they will implement it. Do they have any objection? What are their limitations? What are their reservations? So वो एक लंबा प्रोसेस होता है. सारे मंत्रालय, सारे के सारे स्टेट्स उस प्रोसेस में जुड़ते हैं, सारा सिविल सोसाइटी उस प्रोसेस में जुड़ता है, कंसल्टेशन होते हैं, तो उसमें थोड़ा सा टाइम लगता है. ये जल्दी हो सकता था, बट एक्चुअली इट टुक लिटिल मोर टाइम. आई थिंक 2014 में 12 में ही हम लोग तैयार थे, लगभग 11-12 में, बट थोड़ा सा डिमांड्स थी कुछ और इंक्लूजन की, तो वो और थोड़ा सा लटका. फिर पॉलिटिकल विल का भी एक इशू रहता है, प्रायोरिटी का भी इशू रहता है, उसके लिए फंडिंग का भी एक इशू रहता है. बिकॉज व्हेन यू पास अ लॉ, कोई लॉ तो कितने साल तक ड्राफ्ट में ही पड़े रहते हैं, बट थैंक्स टू दिस प्रेजेंट गवर्नमेंट की जैसी गवर्नमेंट बनी, उसके अगले साल ही ये लॉ जो है पास होके इट केम टू इट वाज एनफोर्स्ड. सो प्रोसेस थोड़ा स्लो है, बट यस, दिस इज हाउ इट इज डन इन द कंट्री. थोड़ा डिले जरूर हुआ, बट वी आर ऑन राइट ट्रैक.
Okay, thank you, sir.
Thank you, sir, for your insightful lecture and patiently answering all the questions and queries. If there are any more questions, we can take them via email or on the WhatsApp group, and the same can be forwarded to sir. Do we have any more questions? All right, I don't see anyone else having questions. So, yeah. Okay, sir. Thank you,
I
sir.
can
Thank you so much.
suggest- Yeah, thank you. I can suggest people if they have more questions, they can probably, yes, they can. You can share it with me, they share with you. And other thing is they can also access. This is called disabilityrightsindia.com. That's a website. So I mean, they can look up there. Probably many cases are highlighted there, and they can see those cases. I think there was some question from Hema Kumari. Can you please share the case list you were talking about? Okay, so that case list definitely I can share. Maybe in next lecture I'll definitely share. And but you can look up also on this website disabilityrightsindia.com. You will get a lot of case laws over there from India. But thank you so much. It was a wonderful interaction. I think interaction is a better form rather than a monologue lecture. But then, yes, it's always good to be interacting with such aware audience.
Sure, I completely agree. And thank you, sir. I'll share the website link on the group as well, so that everyone can reach out on the website and look up for the cases. And thank you, sir. The timings for the next lecture will be emailed to you all very soon. See you in the next lecture then. Thank you, sir.
Thank you. Bye-bye.